State of Washington is now in session. Commissioner Eric Schmidt presiding.
Good morning. Please be seated. First case on this morning's calendar is Green versus Pierce County, docket number 53289-1-2. It's on a motion for discretionary review from Pierce County. Mr. Cornelius, you may begin whenever you're ready.
Thank you.
Good morning, Your Honor. This case arises out of a Public Records Act request for jail staff information that falls squarely within a categorical exemption that is intended to prevent or protect from disclosure that very information. RCW 42.56250 subsection 9. Under that statute, photographs and date of birth information in the personnel files of criminal justice agency workers is exempt from disclosure. The only exception to that exemption allows news media, as defined under Washington's News Media Shield Law, access to that information. The question in the underlying Superior Court case and now here for appeal, and the controlling question of law at issue is whether Brian Green, the plaintiff in that case, at the time of his request established that he was news media as defined by the News Media Shield Law definition. The trial court denied the county's ability to obtain discovery regarding Mr. Green's news media claim and subsequently interpreted that statute to include Mr. Green as news media. The trial court certified its order under RAP 2.3b4 and recognized that the order involves an issue of first impression, which is interpretation of the News Media Shield Law definition. In addition, at this stage of the litigation of the case, the trial court further recognized that to require the county to wait for a final order to be issued before it took an appeal would really impact any meaningful review by the appellate court should the appellate court later determine that the trial court erred in its ruling. Because to wait, the documents that have been sought would have already been produced to the plaintiff. Interpretation of a statute is a question of law. And the trial court certified that there are substantial grounds for difference of opinion regarding interpretation of the news media definition. There are questions regarding terms in the statute. For example, terms involving the definition of entity, terms involving what regular business means. In addition, interpretation of the definition has very wide implications for governmental liability. What the definition means, what's needed to establish who or what is news media impacts how criminal justice agencies will respond to the same or similar type requests. We believe that immediate review promotes the ultimate termination of this lawsuit, and that appellate review should be accepted on the court's certification. Although we believe that the court's certification alone should satisfy the court's acceptance of review, we do believe that there are other grounds for review based on obvious or probable error made by the trial court. In this case, the trial court ignored the purpose of what the Shield Law is meant to provide and collapsed the distinction that the news media definition in the Shield Law makes between a news media as an independent entity and news media as an individual. The purpose of the Shield Law definition and the purpose of the Shield Law is clear and obvious on its face. It's intended to protect from subpoena or other compulsory process or compelled disclosure. In order to be protected from compelled disclosure, such as from a subpoena or summons, an entity or person must be subject to process and jurisdiction of the court. The Shield Law defines news media into 3 separate and distinct categories, and it's only the first 2 categories that are at issue in our lawsuit. The first subsection 5 of the definition, pertains to entities. And entities includes things such as a newspaper or a magazine in the regular business of news gathering and disseminating news. The second category that the definition provides of what news media can be is for individuals, and this is subsection 5B. And that category provides that an individual who is an employee, an agent, or independent contractor of an entity listed in the first subsection, who is or has been engaged in bona fide news gathering for an entity listed in the first subsection. Looking at the definition, in order to be protected from compelled disclosure, a plain reading of the definition, subsections, at issue pertaining to entities and individuals must include the condition that the entity, independent of the individual, be subject to process and jurisdiction of the court to be news media. Here, Mr. Green is an individual with a YouTube channel that he calls Liberty's Champion. And he made a Public Records Act request targeting correctional staff who were working at the Pierce County Jail at the time of his prior incarceration in the jail. The request came from his personal email, and it is a personal request. It is very similar. YouTube is a social media platform, this YouTube channel that he calls Liberty's Champion. And YouTube allows people to interact with video content. It's very similar to other types of social media platforms like Facebook or Twitter or Instagram. People can open up an account with the service provider. They can start sharing information with other users that are also involved with that service provider. At the time of the Public Records Act request, Mr. Green claimed that his YouTube channel met the definition of news media. At that time, he never represented that Liberty's Champion, the YouTube channel, was some kind of structureless organization or not-for-profit, as he did later. There's no corporate or profit or non-profit registration for Liberty's Champion. There's no address or physical location for Liberty's Champion. The trial court recognized that there's no distinction between Mr. Green and Liberty's Champion. And it stated, and this is quote, "In a very real sense, Mr. Green is Liberty's Champion. There is no evidence of any method that would provide for service of process on Liberty's Champion, or how a court could obtain personal jurisdiction over Liberty's Champion. Liberty's Champion does not exist without Mr. Green. Liberty's Champion is an alias for Mr. Green. They are one and the same. Mr. Green has admitted, and the trial court also recognized, that he makes all the decisions and that regarding Liberty's Champion. Mr. Green made this request, Public Records Act request, in his name. He didn't make it in Liberty's Champion's name. He brought this lawsuit in his name. This lawsuit is not brought in Liberty's Champion's name. It's not even included in this lawsuit. In order to qualify under the news media exception to the exemption, he must be an employee, an agent, or independent contractor of a news media entity. That's how the definition works.
Couldn't he himself be the news media? What if I publish a newsletter for my neighborhood? I'm the only one. I write it, I print it, I take it around, and I put it in my neighbor's mailboxes because I'm in school. Am I news media?
As the facts as you've represented them, what I hear is that you're an individual that may publish some pamphlet.
Am I news media?
I would say no.
The statute?
I would say no, because the statute defines news media into three categories. And the two that we're talking about, the category that you would fall under would be the second one, as an individual. And as an individual, in order to be news media, you must be an employee, an agent, or independent contractor of an entity.
Am I not an entity?
I would say no, because
what's your authority for that?
An entity, the statute, the definition shows that the entity can be independent. It's not the individual. It could be a magazine, it could be a newspaper, or any other entity, but it must be subject, that entity must be independent of the individual and subject to process. If you called your publication Frank's Garage Publication, and you're doing it, it is you. The statute wouldn't recognize Frank's Public Garage publication as an independent entity. There's no way to get personal, a court has no way of getting personal jurisdiction over Frank's Garage publication. The court can get personal jurisdiction over me, an individual. But in order for me, an individual, to be news media, I must be an employee, an agent, or independent contractor of an entity, independent of me, that the court can have personal jurisdiction over if the circumstances required. But in this scenario, if it's just someone publishing something out of their garage, there is no way for the court to get personal jurisdiction over that thing, that abstract thing. It's really you. You
But
acting.
if I make a Public Records Act request and assert that I am news media, that I am an entity as news media, I'm publishing this thing, don't I fall within the statute?
One, I believe you would have the burden of proving that you do fall under the statute. You would have the burden of showing that you are an employee, an agent, or independent contractor of an entity that is news media, that would be subject to personal jurisdiction of the court, that could be subject to compulsion.
But I'm subject to compulsory process. You can serve as a subpoena on me.
As an individual.
Yeah.
But as an individual, in order to be news media, you must be an employee, an agent, or independent contractor. That's what the statute provides. And looking at the plain construction of it, there is no other reading that I can see that wouldn't lead to absurd results, where I can create this abstract thing that the court could never have personal jurisdiction over, and now claim that I am an employee, an agent, or independent contractor of really myself. Even though I'm doing this, it's really me. To gain the protection of the SHIELD law, and that's what we have to go back and look at, is the purpose of the SHIELD law is to protect from compulsory, compelled disclosure. And in order to do that, that entity itself, independent of the individual, must be subject to process. It must be subject to personal jurisdiction of the court. And if it's just you, then it's just you subject to that, and you're not the entity. You're a person. And whether you want to call yourself Frank's Garage Publication or some other name, it is still you as an individual, and the court cannot gain jurisdiction. There is no authority that I can see that would allow the court to gain personal jurisdiction over something like that. So when you ask about authority, I don't see it. It's nowhere. But the statute is clear that an individual must be an employee, an agent, or independent contractor of an entity that is news media.
Okay. You've run over your time a little bit, Mr. Cornelius. So if you could wrap up.
I'll wrap up, and I guess I do want to say one thing because it's come up. The trial court was informed, and this court has been informed, that Mr. Green has made a Public Records Act request directly against me during this litigation.
How was that material?
I bring it up only because I want to indicate that Mr. Green has withdrawn at least that portion of his request recently that pertains to obtaining a copy of my badge or date of birth. I bring it up because argument was made in our briefing that is an example of how the court's order impacts litigation or impacts the status quo outside of this litigation and the freedom of the county to act. So I bring it up because it was used as an example for that, and I want to inform the court that Mr. Green recently, on the eve of this hearing, withdrew that part of his request. I don't think it changes our argument. I think there's still an impact, but I wanted to bring that up.
Mr. Thomas.
Thank you, Ryan. I'd like to start off with what we agree on and then focus on what we don't agree on for the hearing. What we do agree on is that this is a very important question of statutory interpretation. And this is an issue of first impression that has broad-reaching implications. But what we agree on stops there. What we disagree on is that this can wait. What petitioner came up and said, that they didn't show any reason why this can't wait and why the orderly administration of justice should be halted in the trial court. As pointed out in the briefing for this, in the trial court, there's two steps, and the trial court bifurcated the proceedings. There's a merits hearing, and then there's a penalty hearing. And at the merits hearing, if the request prevails, then there's a mandatory legal operation of the penalty hearing. And that's what's being halted right now. Because Pierce County is saying, or a petitioner is saying, that there's a substantial conflict of difference of opinion, and this is going to happen time and time again. The history of the statute, Your Honor, is that this was codified in 2007, the news media statute, RCW 5.68.010, subsection 5. And this is a case of first impression. In those 12 years, there has been no other case that any of us can identify of where this has happened before. So petitioners coming up here screaming like that the sky is falling and that there's going to have these huge ramifications immediately if discretionary review is not accepted. And that's just not true. The record is absent of any other case where this has happened in the past 12 years. So while we agree that this is a very important question of law, this very important question of law can wait and should wait until the trial court resolves all the proceedings, including the mandatory legal operation of the penalties and attorney's fees. So let me go into the substantial grounds of difference of substantial grounds for difference of opinion. So petitioner argues in their motion for discretionary review that there's a substantial ground for difference of opinion in the statute. But that's not true because petitioner ignores many of respondents' arguments. The first argument that's ignored is there is a case that does talk about a different subsection of the statute. The Kazakhstan case, which is pointed out in petitioner's respondent's brief. It talks about RCW 5.68.010, section 1, section A. And the court there said that it construed that statute is very broad. That's a direct quote, very broad. And petitioner doesn't point that out in their motion for discretionary review that there's only one, that there's another case that talks about a different side of the statute. But they come back in their reply brief and they said, you know what, this really isn't important because it doesn't discuss what news media is. But it does construe other words that are used in the same subsection, such as any. Any shows up in both in the Kazakhstan case in subsection 1A, and it shows up in section 5 for news media that we're talking about. And in fact, at the trial court, and if this court accepts it here, respondents' arguments will be that any means every, each and all. So it's very broad and encompassing, just like the Kazakhstan cases. So what petitioner is coming up here and saying is that this is a really restrictive definition of news media, and it can only be to this corporate entity, and they're ignoring the plain language of the statute, and they're ignoring the very broad construction of the words any. And the trial court recognized that. The trial court said that it was very broad. The only person who doesn't think it's very broad is petitioner, and that's because they're ignoring plaintiff's arguments. Or they're ignoring respondents' arguments. And they should not be able to skip ahead and have discretionary review granted, skip ahead of the appellate line when they're ignoring the arguments because they cannot prove that there's a substantial ground for a difference of opinion. The second argument that they ignore, and in fact, not only do they ignore it, but they also misstate it and misrepresent it to this court, which was already brought up in the briefing. The First Amendment construes how this court needs to look at 5.68.010 subsection 5. It is agreed by everyone that this is talking about news media. And the First Amendment talks about the freedom of the press. And this court asked petitioner, which I thought was very telling, about publishing a pamphlet as news media. You know, can I publish a pamphlet and be considered news media? That's what our founding fathers did. They worked out of their garages and they published pamphlets in order to rebel against England for the Revolutionary War, which was the founding of the freedom of the press. And petitioner ignores the First Amendment argument, and when he does address it, he misrepresents it. And this is very important in this case because the Supreme Court has ruled, and federal courts have ruled, about the construction of news media, or the freedom of the press. Let me draw attention to some of this case law because this is going to be the immediate argument that this court is going to hear on the merits if the appeal is going to be granted. It's going to be a First Amendment argument. And in Citizens United, the seminal case, Citizens United versus the Federal Election Commission from the United States Supreme Court, 130 Supreme Court 876 at pages 905 to 906 says, quote, "With the advent of the internet and the decline of print and broadcast media, the line between media and others who wish to comment on political and social issues becomes far more blurred," end quote. Mr. Green is an individual who wanted to comment on YouTube about political and social issues. He was talking about how the government operated, whether there was problems in the jail, and whether they were running effectively, which is the point of the Public Records Act. And this is the point of the freedom of the press that the United States Supreme Court is saying. And what petitioner's argument is about this is they misconstrue this argument and they say, look, respondent didn't plead a constitutional challenge. What they're trying to do is invalidate the statute. That's not true. We won. We won at the trial court. We proved that just on the plain language of the statute that Mr. Green qualifies as news media. We didn't have to invalidate the statute. There was no reason for us to invalidate the statute.
At what point does Mr. Green become news media?
The very broad, Mr. Green becomes news media by the very act of publishing on the internet. It's an
So if I create a YouTube channel, I am news media?
if you intend to.
How do you prove intent?
You can look to the FOIA case law. And actually in FOIA, they actually have a 5-part test to define news media. And in fact, this is in the briefing. And what happens in federal court is they use the same term, news media, and they say in FOIA, look, we'll waive fees for news media. And so it's not out of the media shield law, but they use it for the same context of defining who news media is. And they look at how often you publish. They look at when you started publishing. They look at what your audience is. And that was argued at the trial court. That was argued at the merits. That's another argument, and that's in our response to motion to discretionary review. This is another argument that petitioner just ignores. They don't ignore our argument about FOIA and news media. They want to come up here and they want to talk about what news media is, but they want to ignore all of our arguments. It's in the briefing, Your Honor. And if
So who is news media here, Mr. Green or Liberty's champion?
both. If there's a reporter here from the Seattle Times, Mr. Smith. Mr. Smith is news media, and Seattle Times is news media. There's no distinction. And what petitioner is trying to do is they're trying to say, look, only the entity can be news media, and that's not true. Because the person is being summoned with a subpoena, and not just the entity. And so you can't draw a bright line between the entity and the person, and that's why the Kazakhstan court correctly understood that this is a very broad statute. If this court looks at the plain language of RCW 5.68.010, it included everything under the sun. It uses there's no exclusionary language in there at all. And then also it has to be construed in conjunction with the First Amendment.
So you're saying the FOIA definition defines who's news media?
Yes.
For purposes of this statute?
Yes, and we argued at the trial court that Mr. Green meets that too. And that wasn't an argument here because they don't address that. And so I would refer you to the briefing in the trial court. That would be in our response, or our opening merits brief and our reply merits brief for FOIA, which is in the appendix that petitioner wrote. And so these arguments aren't addressed, and these are important arguments, and these are important questions that Your Honor is asking. And respondent wants to answer these and have a full and frank discussion with this court because this is an important question and it is important that this court gets it right. But it should not reward petitioner for ignoring respondent's arguments and then misconstruing respondent's arguments in order to try to gain a tactical advantage, to skip the line, and to advance this case for their interests when it's going to disrupt the orderly administration of justice. Does the court have any other further questions?
No, thank you, Mr. Thomas.
Thank you, Your Honor.
Mr. Cornelius, you used up your rebuttal time, but I'll give you 1 minute.
Thank you, Your Honor. Let me just respond real quickly, I guess. First off, the way it doesn't apply. We have our own definition to refer to another definition, a federal definition of what news media is not applicable, and we made that argument in our briefing in the merits. The statute that we have is the one we're working for, and the legislator here in Washington defined what news media is. As far as the Kazakhstan case, that case deals with something completely different, a different portion of the statute. It deals with what the source of news can be and talks about how broad that could encompass. What's telling about that case is that it involves an entity that is actually subject to personal jurisdiction. Again, we talked about that, I believe, in other briefing in our materials that were made, certainly on the motion to compel, I believe that was brought. Lastly, the issue that the court's having, I think, is a slippery slope. This idea of a pamphlet being printed out of a garage. What we're talking about here is a social media platform. We're talking about things like YouTube, we're talking about Facebook, we're talking about Instagram, things like that. Just having an account, just posting information to your followers, to your members, whatever they're called on that platform, doesn't automatically make you news media. And I think that's where the question in court was going. There's got to be something more than that. And what the definition provides for here is that news media must be, as far as an entity, independent of an individual. We're not arguing that an entity must only be news media. We're arguing, this is what we tried telling the trial court, an entity must be independent of an individual. Mr. Green is an individual in this case. He made this request in his individual capacity, and he has to satisfy the statute as an individual. And to be an individual, to be news media, he must be an employee, an agent, or independent contractor of an entity that is news media, an entity that is independent, subject to service of process and personal jurisdiction of the court. And that's the argument that we've made.
Thank you, Mr. Cornelius. Thank you, Mr. Thomas, for your arguments. I'll issue a written ruling as soon as possible.